says, there shall be no excessive bail. And that's been the law of our land ever since. But that begs a big question, doesn't it? How much is excessive? If there can't be any excessive bail set by a court, how do we know what that means? Is there a yardstick? Is there a way to measure the bail that the court set to make sure it's not too much? And you know what? That question went unanswered for a long, long time in this country. And there was a lot of argument about it, as you can imagine, in criminal proceedings. Finally, in 1951, the United States Supreme Court took up a case called Stack v. Boyle. Stack v. Boyle. You go to this website, you can get a copy of it. I've got the opinion. Let me read you just a little bit of the opinion of Chief Justice Vinson in Stack v. Boyle, United States Supreme Court. Very important language here. Quote, the right to release before trial is conditioned upon the accused giving adequate assurance that he will stand trial and submit to sentence if found guilty. The right to release before trial is conditioned upon the accused giving assurance to the court. What kind of assurance? Justice Vinson tells us. He says, the modern practice of requiring a bail bond or the deposit of a sum of money subject to forfeiture serves as additional assurance of the presence of an accused. Assurance of what? The presence of the accused. You see, before he even gets to talking about what's excessive, he says, I want to make sure we all understand something. It's really, really important to get the defendant to his trial. That's first. We gotta do that. We gotta do that. Because if we don't, the whole system doesn't work. And then the Chief Justice said this, bail set at a figure higher than an amount reasonably calculated to fulfill this purpose is excessive under the Eighth Amendment. Fulfill what purpose? The purpose of the presence of the defendant. So what the United States Supreme Court told us in 1951 about excessiveness is really two things. It said, don't forget the first thing. Get the defendant to court, but be fair about it. Don't make it harder on him than you need to make it to get him to court, because if you do, that's excessive. Well, that's very, very important language. If it were taken literally for just what it says, it could resolve a lot of controversies today. I learned some Latin phrases in law school, and I don't remember. I think I remember two of them. One, I think is very appropriate here, and that phrase is sine qua non. Anybody know what that means? Sine qua non? It means without which nothing. My breath is the sine qua non of my continued living in this body. Without it, I got nothing. The appearance of the defendant at trial is the sine qua non of our entire criminal justice system. Because precious things are lost to never be retrieved if he's not there. You see, when a person is charged with a crime in our country, they have going for them a thing called the presumption of innocence. And you know what that means. It means that they're presumed innocent until they're proven guilty. But you know what? It means a little bit more than that. It means that we can't make that person put on one scintilla of evidence of his innocence. He doesn't have to do that. The burden is all on the government. The prosecution has to prove to the fact finder beyond a reasonable doubt that the defendant did what he is charged with having done. And he doesn't have to even get up there and say, no, I didn't. But the opportunity of the government to put on its evidence of guilt beyond a reasonable doubt is lost if the defendant is not in court. He needs to be there for that. Another thing that's lost is the right of closure for the victims. They have a right to have their wrongs redressed. And if he's not there, they can't get closure. And that's important. Maybe most important, we've lost the principle of accountability if the defendant is not there for his trial. Personal accountability is the cornerstone of the edifice of our whole criminal justice system. If a person is proven to have committed a crime beyond a reasonable doubt, he needs to be accountable for that. The rest of society needs to know that one has to be accountable if he commits an offense against the rest of the society. Those things are lost if the defendant fails to appear. So the court, you see, then is, well, I'm going to run out of time, Dr. Morris. The court is bound then to walk a tightrope. It can't lean too far in favor of the defendant's right under the Eighth Amendment. It can't make it too easy for him, because if it does, he might not come at all. But it can't make it too hard for him, because if it makes it too hard for him, it violates his rights. So you've got society's right to have the person there, and you've got the defendant's right not to be mistreated by how you get him there. You see what I'm saying? And so the court has this balancing act. And it has to choose, which method of release am I going to use to accomplish those two objectives? Because there's more than one method of release. You don't just have to get a bail bond. Sometimes people get released without a bail bond. There are basically two types of release. There's the secured release, and then there's the unsecured release. The secured release would be a commercial bail bond, certainly, or all cash. $10,000, mother brings down $10,000. In some states, they let you put up property, too. Free and clear real estate, no homestead exemptions or any of that kind of stuff, but free and clear real estate. And most of the states that allow that say it's got to be worth 20% more than the amount of the bond according to a recent certified appraisal. And then somebody can come down and put up their land to guarantee the reappears. The whole idea is behind secured release is just what that means. That says secured. You want somebody who's going to lose something watching the defendant, helping to get him to court, and that's what it's all about. Unsecured release, how does that work? Well, it may be a case where the court says, you know what, taking all the circumstances into account, I don't need any physical security. I just need the guy's word. If he gives me his promise that he'll come back, or that he'll pay the $10,000 if he doesn't come back. Considering his standing in the community, who he is, what he does, he's got a perfectly clean record. I can see how this thing could have happened. Maybe it was an accident where somebody was hurt involving a DWI on this man's part, whatever. And the court may say, you know what, he's not going to run away. He's a zero flight risk. There's no way this man is not going to show up for his trial. No way. I'm not going to make him put up anything. The only security that I want is just his word. Well, that's an unsecured release. Now, those happen in two different ways. The court may simply take the man's word, but in large counties, there is a facility that's funded by county taxpayers called the Pretrial Service Agency, the County Pretrial Service Agency. And it's made up of people who, when somebody gets booked into the local jail, one of their interview officers will go in and interview this man. And then when he comes out for the arraignment before the magistrate, for setting a bail and conditions of release and all of that, this person may go before the magistrate and say, Your Honor, we want to recommend that you release him on his own recognizance, but into our care. We will take responsibility for getting him to court and for seeing that he comes back. Now, we're not going to guarantee the payment of the $10,000, but we'll guarantee, we'll assure you that we're going to keep up with him and we're going to get him to court. And incidentally, he got in this problem because he's got this drinking problem. Maybe you want to sentence him to do a little rehab work, and we'll get him to a facility. We'll see that he gets his rehab work done. Makes sense. So those are the two ways that somebody might be able to get out of jail on an unsecured release. Now, remember that the whole idea for the judge is, I gotta make sure he comes back to court. That's number one. Well, is there a way for a judge to know which of these methods, there are 4, 5, or 6 of them we've talked about, which of these methods does the best job of protecting the Eighth Amendment right of non-excessive bail belonging to the defendant and the society's right to have the person come back to court? Yes, there's a way for the judge to know that. And the way he can know it is because a number of national, very credible studies have been done just on that subject. How do they perform? How do these various methods perform? One of them is a study done by the Federal Bureau of Justice Statistics, which is a part of the United States Justice Department. They would go out every 2 years. They would go to the 75 most populous counties in the country. They would pick 55,000 state case felons, and they would track them for a year. And they would say, okay, what was the failure to appear rate for each one of the methods whereby these people got out of pretrial custody? Here's what they said in one of those 2-year reports, and they're all about the same. I've looked at all the 2-year reports, and they all say just about the same thing on the conclusions. Defendants released on an unsecured bond were most likely to have a bench warrant issued because they failed to appear in court. There's another one. The University of Chicago Law School sponsored a big study trying to find the answer to that same question. The study was performed by a couple of preeminent research specialists. Here's what they concluded. Defendants released on surety bond, a bail bond, are 28% less likely to fail to appear than similar defendants released on their own recognizance, on their own promise. And if they do fail to appear, listen to this, folks, if they do fail to appear, they're 53% less likely to remain at large for extended periods of time. Why is that? It's because nobody goes after them. Everybody that's let out on an unsecured release knows 3 things for sure. And I'm not saying they all take advantage of these 3 things, but they know these things. They know that they don't have to come back to court. Because if they don't come back to court, nobody's coming after them. And they know that nobody's coming after them because nobody's going to have to pay anything if they don't come back to court. But somebody who's out on a secured release knows 3 things too. I got to go to court, because if I don't go to court, they're coming after me. And they're coming after me because they don't want to pay the bail loss. That's the second study. There was a third study. This one was a little more provincial. It was done on the 4 largest counties in California a few years back. San Diego County, Los Angeles County, Sacramento County, and San Francisco County. It was performed under the leadership of Dr. Michael Block, one of the preeminent criminologists in the country at that time, and he was a professor at the University of Arizona. Here's what that study found. Despite the fact that the bond releasees, that is, the defendants who were released on bond, tended to be more dangerous and more chronic criminals The study found that a defendant released on recognizance without financial security, you ready, was twice as likely to fail to appear for trial. Not only, it says, does the private market perform better the main task of assuring the appearance of criminal defendants, thereby reducing the social cost of crime, but now we see it does it at substantially less cost to the taxpayers. The last study, and there are a lot of these studies, but the last one I want to mention to you, because I'm going to run out of time, the last one I want to mention to you is a study that is the buzz of the country right now. This study is being talked about a lot. I hear about it every week. It was a study done on over 22,000 releasees in one county for the year 2008. And the reason they went back to that year is they wanted to give their cases time to run to conclusion so they would have accurate information. Here's what it said. Overall, analyses based on the data explored here suggest that commercial bonds were the most successful in terms of defendant appearance rates. Now, it did something a little different than the other studies, and this is one of the things I think that's captivating the interests of people far beyond the county and state where the study was done. It goes into some detail about it determined the cost of a failure to appear, the administrative cost to the county of a failure to appear. And then it utilized that information and measured it against the failures to appear of secured and unsecured. And the conclusion it came to was that in the year studied, the use of commercial bail bonds saved that county over $11 million because of its superior appearance rate. That county, incidentally, was Dallas County. And the study was done under the leadership of Dr. Morris by the University of Texas at Dallas. Now, would it surprise you, I've got to talk about 7 or 8 minutes about this, and would it surprise you if somebody won't know? So what do we know? We know from these studies that commercial bail bonding, secured release, dramatically outperforms other methods of release in terms of getting people back to court and at the same time attempting to preserve